generative AI. It's kind of hard to miss these days, right? Images, text, even coding, it seems like it's popping up everywhere. And behind it all, powering all of this, are these massive, I mean, truly colossal amounts of data.
Oh, absolutely. You hit the nail on the head. I mean, at their core, these machine learning models are all about pattern recognition. And to really grasp those intricate, those complex patterns, you need exposure to, well, huge data sets.
Okay, so we've got this vast sea of data that's being used to train these AI models. And a lot of that data, we're talking books, music, images, stuff that's protected by copyright. And that brings us to what we're diving deep into today. The copyright implications of using this protected material to train these AI models, these models that just seem to be getting more powerful all the time.
You got it. And for this deep dive, we've really dug in. We've gone through a ton of legal analyses. We've looked at discussions of ongoing court cases, and well, it's complicated. The interpretations, the legal landscape, it shifts so much as you go from country to country.
It really does sound like a legal maze out there. So for you, our listener, our mission today is to cut through the jargon and really get to the heart of the legal questions being debated. And we also want to give you a sense of how different countries are tackling this whole collision of, well, cutting-edge AI and long-established copyright law.
And it's so important. I mean, data is becoming this incredibly valuable commodity. Having some clarity, some consistency in how we think about this legally is going to be crucial for everyone, the people building the AI tools and the creators whose work is, well, potentially being used in that process.
Right, right. Okay, so before we jump headfirst into the legal arguments, can we just back up for a second? Let's get a grip on the technical stuff. You talked about how these models learn from data. How does that actually work? What's this training data pipeline everyone keeps mentioning?
Well, it all starts with data collection.
Yeah.
I mean, it can involve a bunch of different things, accessing public data sets, the more controversial practice of web scraping. And then there's this thing called robots.txt. It's kind of like a digital no trespassing sign that website owners can use.
Okay, so even at step one, getting the data, there's some gray area.
Yeah, there can be. And then you move on to pre-processing. This is where you're really digging into the raw data, taking out the useful parts, structuring it in a way that the AI model can actually understand, and you often have to clean it up, remove personal information and things like that.
So the data's cleaned, it's organized. Then what? I keep hearing these words, tokens, transformers. What are we talking about here?
Well, for models that work with text, a really key step is tokenization. This is where you break down the text into smaller pieces. And those pieces, they're called, well, tokens, words, parts of words, punctuation marks, all that. And just to give you a sense of the scale here, they say ChatGPT-3 was trained on over 300 billion of these tokens.
300 billion. That's mind-boggling. So what happens to those tokens?
Well, they have to be converted into a format that the model can actually use, right? So that's encoding, turning all that text into a giant sequence of numbers. And then you get to the transformer architecture. It's kind of the backbone, the foundation for most of the major large language models we see these days, ChatGPT, Llama, Mistral 7B, all of them.
The engine, so to speak.
Yeah, exactly. And these transformers, these things called attention heads. It's like they're assigning a level of importance or weight to different input tokens.
It sounds like they're trying to figure out the context, almost like how a person would.
Yeah, you could say that. And during pre-training, that's when the model really starts learning the statistical relationships between those tokens. And those relationships, they're stored as parameters, which, well, include these things called weights. It goes through tons and tons of examples. Adjusting those weights, it's trying to predict the next token in a sequence, trying to minimize those errors. It's like building its own internal grammar rule book, but it's based purely on statistics.
So the more data it's exposed to, the better it gets at predicting. Now, you said something earlier about emergence. What is that all about?
Yeah, so this is really interesting. When you make these models larger, give them more data, more parameters, they start doing things they couldn't do before, like in-context learning, where they can learn new tasks from just a few examples. It gets way better as the models get bigger. The crazy thing is, we don't really know exactly why.
So a kind of unexpected leap in capability just by scaling up. Okay, so let's say you want an AI that's really good at a specific task, writing legal stuff or medical diagnoses, things like that. There's this thing called fine-tuning, right?
Right, exactly. So fine-tuning is where you take a pre-trained model and you give it even more training. But this time, it's on a very specific data set, right?
Yeah.
To really hone its skills for that particular area. And there are a couple of approaches here. Domain-specific fine-tuning, which uses entirely new data, but sometimes the model can kind of forget its broader skills. And then there's mixed data fine-tuning, which tries to avoid that by combining the original data with the new specialized data. And what's interesting is that if you're doing that domain-specific fine-tuning, you often don't need access to that original massive training data set. The model can just build upon what it's already learned, you know?
Okay, so we've got a good handle on how text-based AI learns. What about image generation? Those tools like Midjourney and Stable Diffusion, are they doing the same thing?
Well, not exactly. They often use what are called diffusion models. They work differently. Instead of processing data sequentially, they kind of take this different path. They take an image and they slowly add noise to it until it basically becomes pure static. And this happens in something called latent space, which is this numerical representation of the image, but it's like more compressed, more abstract.
Okay, I'm trying to picture this. It's like adding static to a TV signal until you can't see the picture anymore.
Yeah, that's a good analogy. And then the model learns to reverse that. It learns to remove the noise bit by bit to get back to the original image. So it's learning to unnoise, to put it simply.
And how does the text prompt, the words we type in, how does that guide the whole thing?
Well, that's where these text encoders come in. They take your prompt, the words, and they turn it into a numerical representation in that same latent space. So it's like translating your words into the language of the model. And that text encoding, it basically guides the noise removal process. The model starts with that random noise, and then it gradually removes it, guided by your words, until it generates something that matches what you described.
Fascinating. So we've got these two totally different approaches, sequence and transformers, and this noise manipulation and diffusion models. And you said that in both of them, the learning happens by adjusting these internal numerical representations.
Right, exactly. Whether it's parameters and weights in transformers or vectors in this latent space for diffusion models, that's where the magic happens, so to speak. That's how these models learn from all this data.
Okay, so we've got this picture now of how AI is trained using these enormous data sets that might include copyrighted material. Now let's get to the legal side of things. What's the big copyright issue here with this training data?
Well, the core principle is the right of reproduction that's granted to copyright holders. You know, international agreements like the Berne Convention, laws in the US, the UK, the EU, they all give creators the sole right to make copies of their work. And that includes digital copies, of course.
So when you download and store all this copyrighted material to create these training data sets, that's considered copying. That's reproduction.
Yeah, pretty much everyone agrees on that. These aren't, you know, temporary copies like the cache in your web browser. They're stored specifically for training that model. And in Europe, the courts have taken a really narrow view of what counts as a temporary copy. So these training data sets definitely don't qualify for that exception.
So using this copyrighted stuff to build the data set sounds like, well, it sounds like a pretty clear case of copyright infringement. But is it always that simple?
Well, not always. I mean, one of the tricky things is the sheer scale of it all and the way the data gets transformed. We're talking data sets with billions of data points. And the original material, it often gets processed, broken down into all these numerical representations we've been talking about. It's not always a direct copy, a one-to-one thing. And then you've got this idea in copyright law, the idea-expression dichotomy. It's this idea that copyright protects the specific way something's expressed, not the underlying idea.
You can't copyright the idea of a love song, just a particular song with its specific melody and lyrics.
That's right. So some people would argue that these models are learning patterns and relationships, you know, like underlying ideas, not copying specific expressions.
Okay, so are there any exceptions or limitations to copyright that might cover this data being used for AI training?
Yes. And this is where the real legal debate happens. Copyright laws around the world, they have these exceptions, these limitations, right? And the question is, can AI training fit under those? Internationally, there's something called the three-step test that sets out the conditions for any acceptable copyright limitation.
Okay. And what about in the U.S.? I know there's a lot of talk about fair use.
Yeah, in the U.S., the debate really centers around this concept of fair use. They have this four-factor test the courts use: the purpose and character of the use, the nature of the work, the amount used, and the effect on the market for the original work. And when it comes to AI training, that first factor, whether the use is transformative, that's really been at the center of things.
Transformative. So is training an AI, is that considered a transformative use of copyrighted material?
Well, there are arguments on both sides. On one hand, you could say, yeah, it's transformative. You're taking this expressive work, this song or image, and turning it into something non-expressive like model parameters.
Yeah.
Or you're creating new outputs that don't look anything like the original. But then on the other hand, if the AI generates outputs that really closely resemble, almost copy the original, then maybe it's less transformative.
So it all comes down to how the AI is used, what it ends up creating, and what about the potential harm to the market for the original work? That seems relevant here.
It's definitely a big concern. Some people worry that AI could seriously reduce the demand for, human-created works. If AI can make illustrations, write news articles, that could have a huge impact on artists and journalists. And we saw those concerns come to a head with the screenwriters' strike in 2023. And then you've got this whole market that's emerging for licensing training data. Companies like Hazy offering synthetic data, OpenAI doing deals with the Associated Press and others. Whether that strengthens the argument against fair use or if it's just AI companies trying to manage the legal risk, it's still up in the air.
So fair use in the US, it's a bit of a moving target when it comes to AI. What about the EU? Don't they have specific exceptions for text and data mining?
Yeah, they do. The EU has tackled text and data mining, or TDM,
Yeah.
in their copyright directive. Article 3.1 lets research organizations and cultural institutions do TDM for scientific research. And copyright holders can't opt out of that one. But some critics say that research exception doesn't really address the commercial uses of AI.
Right. And what about TDM for commercial purposes in the EU?
Well, Article 4.1 covers that broader use, but there's a catch. It only applies if copyright holders haven't specifically said, hey, you can't use my stuff for TDM. And they have to say that in a way that computers can understand, it's like using robots.txt. It's like putting up a no data mining sign.
Mhm.
Getty Images actually tried to use that argument in a case against Eliana in Germany, but the court ended up basing its decision on that research exception instead.
Okay, so the EU has this opt-out mechanism for commercial TDM, but then there's this whole question of what counts as a lawfully accessible work. What does that even mean?
Yeah, the directive itself isn't crystal clear on that. But there are some hints in the recitals. It seems like they're talking about non-infringing content, stuff that's online with permission from the copyright holder through open access or some kind of agreement. The idea is that these TDM exceptions shouldn't be a way to get around using clearly infringing content. And the EU also has rules against breaking through digital locks, technological protection measures. So that also points to this idea that you should only be mining legitimately accessible stuff.
Okay. And just briefly, what about the UK? What are they doing?
The UK has been having a lot of discussion, consultations about their stance on AI and IP, but they haven't fully figured out their legal framework yet. Still work in progress over there.
And are there any quick examples from other countries?
Yeah, in Israel, their justice ministry has said they think fair use covers most machine learning.
Mm.
But some legal experts over there have said, hold on, that might be too simple. It doesn't really consider the value of all that training data or
Yeah.
the impact on creators.
Okay, so there's a real mix of approaches out there. I imagine that creates some serious headaches for AI developers that operate in multiple countries.
Oh, yeah, absolutely. The lack of international agreement, it means they have to deal with all these different rules, different laws. What's legal in one place might not be legal in another. It's a mess.
So we've talked a lot about reproducing copyrighted material for those training data sets, but what about when that data is like encoded in the model itself, in the parameters and weights? Is that a separate copyright issue?
Oh, that's a great question. And it's one that people are really arguing about right now. Whether the data is actually stored in those parameters and weights, I mean, that gets pretty technical. Especially with large language models, they're kind of these black boxes, even to the people who create them.
So even figuring out what's going on inside those things is a challenge.
Yeah, totally. But research is, always moving forward. There have been some really interesting developments. Like Anthropic is doing this work on understanding what specific neurons in a model, what they've actually learned, trying to find these features. It's pretty cool stuff.
Okay, but back to the copyright issue. If the data is encoded in the model, could just giving someone that model, could that be considered a form of sharing infringing content?
Some copyright holders are saying exactly that. If the model can, like, remember and spit out copyrighted material, even in this encoded form, then giving that model to people, well, it could be seen as distributing that infringing content too.
Mm.
And then there's the question of who's actually doing the infringing. Is it the people making the data set, the ones providing the model? Especially when you think about fine-tuning, a lot of times you just need those encoded parameters to fine-tune a model. You don't need the whole original data set.
Okay, so it gets pretty murky pretty fast. How would you even prove that a model has memorized and can reproduce specific copyrighted stuff?
Right? It's tough. And research on this is ongoing. Studies have looked at models like Stable Diffusion and GPT-NEO, and in general, they've found that the rate of direct memorization is pretty low, but it could be higher in certain situations. If you fine-tune a model on a small data set that has copyrighted material, then maybe it's more likely. And for copyright holders, it's always hard to prove that what the AI generates is really similar to their work, especially when you consider that AI outputs, they're often the result of all this statistical stuff, not like someone just copying and pasting.
Right. And to make things even more complicated, you've also got this retrieval augmented generation, or RO. How does that fit into this?
Yeah. R is a different beast altogether.
Hmm.
Instead of relying on what's like baked into the model, it goes out and grabs information in real time from some external source.
Yeah.
And then it uses that to generate its output. So you could argue that it's not really storing the copyrighted stuff in its parameters. It's just, accessing it when it needs to. Maybe that helps with some of those copyright concerns.
Okay, so we've talked a lot about national copyright laws, but what about when AI training or distributing these models? What about when it crosses borders? We have to talk about extraterritoriality in copyright law, right?
Oh, we definitely do. It's such a key issue. The basic principle is territoriality. Copyright rights, they exist and they're enforced within a specific country. That's it. A U.S. copyright doesn't automatically mean you have rights in the U.K. The European Court of Justice, they made that super clear in a case called Lagardère.
But online, things are all over the place. How do courts decide if something that happens online, something that might involve multiple countries, how do they decide if it's actually infringement in their country?
Yeah, it's tricky. They use this concept of localization, trying to figure out if enough of that infringing activity happened in their country for their law to apply. Sometimes they look at where it started, sometimes they look at where it ended up or had its main effect. But the problem is there isn't one set of international rules for this. And a lot of copyright laws don't even mention it. So you end up with different countries doing things differently.
So, what's the general approach in the U.S. when it comes to extraterritorial copyright infringement?
Well, U.S. courts, they've historically been pretty hesitant to apply their copyright law outside the U.S. There's this idea that U.S. law is for U.S. territory unless Congress specifically says otherwise. There was a case, Supafilms, where the Ninth Circuit really showed how much they resist applying U.S. copyright law extraterritorially.
And how does that compare to the EU? I've heard about their targeting test.
Right. The EU has gone in a somewhat different direction, especially when it comes to online stuff. The European Court of Justice, they have this targeting test.
Yeah.
They look at whether what happened online was specifically aimed at people in the country where copyright protection is being claimed.
Yeah.
Like if someone in France is selling fake handbags to customers in Italy, they really hammered that home in the L'Oreal v. eBay case and the Football de Taco case. Just because something is accessible online in a country, that's not enough. You need to show that whoever did the thing was really trying to target that specific country.
Makes sense. You can't be held liable for copyright infringement everywhere just because your website is global. And what about that case in the UK, Getty Images v. Stability AI? How did they deal with the fact that the AI training might have happened outside the UK?
Yeah, that case really got people thinking about extraterritoriality and AI. Stability AI, which is a UK company, they argued that they hadn't broken any UK copyright laws because they did all their training somewhere else. They said, look, nobody involved in training our Stable Diffusion model was in the UK. None of the images were downloaded or stored in the UK. And when the High Court looked at their request to dismiss the case, the judge basically said, yeah, the evidence supports that. So they let that argument go to trial, which suggests that where that training happens, that could be a big deal for UK copyright law.
Sounds like they're taking a more traditional territorial approach. Okay, so let's talk about the EU again. They've got their AI Act on the horizon. Does that have any implications for copyright, beyond the EU's borders?
It does, yeah. Recital 106 and Article 53, they basically say that if you're providing a general-purpose AI model, you got to have a plan to respect EU copyright law. That includes saying where your training data came from and showing that you're doing things the right way when it comes to copyright. But some legal folks are arguing about how much legal weight those policies really have. They're saying just having a policy isn't enough. You got to actually follow it.
Right, actions speak louder than words. And what about the reach of the AI Act? Does it go beyond those specific policy requirements?
Oh, yeah. Article 3 gives it this pretty wide reach, similar to GDPR. It covers AI systems that are put on the market in the EU or that affect people in the EU. Doesn't matter if the company is actually in the EU or not.
Right.
It's a classic example of the Brussels effect. The EU makes a rule, and everyone kind of has to follow it because, well, the EU is a big market. And we're seeing this idea, this extraterritorial approach, popping up in other places too. Brazil, South Korea, Canada, they're all thinking about it.
But how does all this, especially these copyright policies, how does it square with the whole territoriality thing in copyright law? Like, the Bernier Convention says that copyright is supposed to be independent of protection in the country of origin.
You've hit on a real point of friction here.
Hmm?
If the EU is trying to regulate AI training that happens outside of the EU, and they're trying to do it through copyright, well, some people might say that's stepping on the toes of other countries' copyright laws.
Yeah.
There's a real tension there.
Okay, so we've got all these legal questions swirling around, and it makes me think about something else entirely. We hear about patents for product by process. Is there any connection there that might help us think about AI and copyright?
That's a really interesting thought. And there might be, though it's not a perfect analogy. So a product by process patent, it protects something that's made using a specific patented process. And because patents are territorial, if you use that process in a country where it's not patented, well, you're not infringing.
Okay, so far so good.
But in a lot of places, and in the Paris Convention, you can have rights over products that were imported, even if they're made using a patented process somewhere else. So even if the process itself wasn't infringing where it happened, the product can still be a problem.
Okay, I see where you're going with this. So could we see something similar with AI, where the focus is on what the AI creates, the output, and whether that's imported or used commercially somewhere, even if the actual training happened somewhere else entirely?
It's definitely something to think about. Copyright law has always been very territorial, that's for sure. But those product by process patents, they show that it is possible to extend legal protection to things that are made outside a country's borders. Whether that will happen with AI, though, that's a big question. There are a lot of established copyright principles to consider.
It feels like this whole conversation boils down to this fundamental conflict. We want to protect creators, encourage creativity, but we also need tons of data to make AI better. Are we headed toward a world where we license all this training data, or will we see more copyright exceptions to help AI development?
It's the million-dollar question, isn't it? And there are strong arguments on both sides. Copyright holders, like the Authors Guild, the New York Times, Getty Images, they say they deserve to be paid when their work is used to train these powerful AIs. They're worried about AI hurting the market for their work, and you can see that in the screenwriters' strike, too. Then you've got the AI folks who want those exceptions to help AI move forward. And then, of course, there's this whole market for training data licensing popping up. It could be a way for creators to get paid and for AI companies to be on the right side of the law. But what that means for the future of fair use, I don't think anyone knows for sure.
Finally, we touched on this earlier, secondary liability. Could the people who make the data sets or the AI models, could they be on the hook if someone uses their AI to create something that infringes copyright?
Well, to prove secondary liability, you usually have to show that they knew what was going on, that they knew people were using their AI to break copyright law. But with AI, it's really hard to prove that the output is similar enough to someone else's work to be considered infringement. And the research suggests that AI doesn't usually just memorize entire copyrighted works. So all of that makes it really tough to say that the dataset creators or the model providers, that they knew what was going on.
It seems like we've only scratched the surface of this whole thing. What are the key things our listeners should take away?
The big one. The legal rules around using copyrighted material to train AI are, well, they're a mess. And they're changing all the time. There's this huge clash between protecting creators and needing data for AI, and different countries are doing things differently. The U.S. has fair use, the EU has their TDM exceptions, and a lot of other countries are, well, they're still figuring things out.
Right.
Then you've got the technical stuff, how AI actually learns, that adds a whole other layer of complexity. And then on top of all that, you've got countries wanting to control AI within their borders, this digital sovereignty thing. It's all connected.
It sounds like the legal battles are just getting started. And as AI gets better and better, we're going to see more and more legal challenges.
Oh, absolutely. And this isn't just some abstract debate. It's going to have a real impact on creators, on innovation, on everyone, really.
And with that, here's something for you, our listener, to ponder. With all this complexity, all this push for countries to control AI, what will international collaboration look like in the future? Will AI become this this fragmented thing, different rules in different places. What will that mean for the people making AI and for all of us who use it? It's something to keep thinking about as this whole thing keeps unfolding.